Hello, everybody. How is everybody this morning, this afternoon, this evening, depending on where you are? How are you? And thank you guys, for smashing that like button on the way in. Also, once you smash the like button, please make sure you have live chat at the top of your chat screen so you don't miss anything. Good morning, Dawn, Leslie. Hello, and welcome. I have the recording of Lori Vallow's court appearance yesterday, so you're going to get your first look at her. Hello, soul survivor. How are you? Good to see you guys all here. Thank you for smashing the like. So as soon as we get a bunch of people in here, you guys, we will get going right away on this. Chad Daybell was also in court yesterday. Hello, Willow. On the trail, Kim. Hello, everybody. Okay, so let me just get my audio set up here. I'm doing great, Soul Survivor, and I hope you are too. It's still a little chilly here, but it rained most of the night, which took away all the snow we got yesterday, so that was a bonus. So you are going to see the hearing. I do have the video. So we are going to go over that. And what does this mean for Chad? Chad also had a hearing yesterday. And I do have the recordings of that, but it is very, very lengthy. Hello, Anne. Hello. So what I think I'm going to do after this hearing, and once I show you this hearing, once this is uploaded to YouTube, I will put the links for Chad's hearing. I was going to do them all, but Chad's is very long. It's in 3 different segments. There was a lot of arguing going on in Chad's. A lot of the argument was basically about cost. Hello, Shelly, sorry. Leslie. Sweet Sherry, hello. Alicia, hello, and welcome. You're going to get a look at Lori, and she is in court. She's in court for her arraignment. So you guys are going to be able to see that. And like I was saying to everybody else, I do have Chad's. And what I will do is I will put it in the description of this video once we are done watching Lori. And her facial expressions and stuff like that, it's just like, Shelly, I have not seen any emails yet. My daughter usually goes through them, and if it's something specific for me and not about a read, then she does forward that to me. I don't know if she's had a chance to do that yet. Yeah, she looks pretty scary. She's not, she's aged. Hello, Elizabeth. So we're going to see that. We've got about 31 people in here, so we're going to get going on it. But I just want to give you the rundown on Chad's. A lot of his was fighting over the cost of having the whole trial in Ada County other than Fremont. And then they gave breakdowns of what it would cost to just select the jury in Ada County and have them sequestered in Fremont County. And I think like the bottom line is it's over $500,000 if they were to have it in Ada County, as to if they selected the jury in Ada County and brought the jury to Fremont County, it would be like around the $200,000 to $300,000 mark. So it would be a lot. Elizabeth says Botox wore off for sure. Absolutely. Yep. But she was still able to get her hair dyed. So she won't be getting that done anymore at the jail. But I'm assuming she had a really cushy stay for almost the last year at the state mental hospital. She had a nicer bed. She had better meals. She could wear her regular clothes. Well, she's not going to have that now that she is back at the jail. So with that being said, you guys, let's get into it. Oh yeah, she's able to have the lipstick on. You'll see. You're gonna get to see. She's got a brand new pair of glasses. No more contacts. So let's get into it, you guys. I'm going to share it. And we're going to watch through it. Oh, almost forgot to share my audio. We're going to watch through it. And I'm going to ask if you have any questions regarding it, leave those to the end and I will answer whatever I can. But it's very interesting. And Lori has another defense attorney who is death penalty certified. So she still has the Robichaud or whatever his name is. But she now also has John Thomas, who is this little guy here. And their facial expressions remain the same throughout this whole hearing. And Lori is pretty much following suit. But she's evil. It's like she's earned the respect to be bashed. When her looks to her are more important than her deceased children, she gives up all rights not to be bullied, as far as I'm concerned. And I don't agree with bullying, but yeah. So we're going to watch this hearing. There's some very interesting things that are going to happen in here that you're going to see. They are forcing, so this is Robichaud, who she's had that replaced Mark Means. Well, he was actually doing the case with Mark Means as death penalty qualified because Mark Means wasn't. Mark Means is now off the case, so they always need a second attorney in a death penalty case. So this is the indication. It has not been ruled a death penalty case yet, but this is your first indication that the prosecution is going to be asking for the death sentence because they have the two attorneys, okay? And I mean, they usually have a team anyway, but in this case, both are death penalty case certified. So this is the new one here. This is John Thomas. The defense is good. The prosecution is going to be over here. We're going to see them. Also, a lot of people were asking who the two men were that are seated behind Lori. Those are the initial LE that were there when the bodies were discovered. Okay. And watch them because their face says everything. You're also going to see JJ Vallow's grandparents, and they break down quite often. It's very heart-wrenching. Trigger warning for people that are sensitive to this kind of thing. It is heart-wrenching. Lori is going to stand true to her demeanor and her character in this that you're going to see. So without further ado, let's get going with this. Please push 1 in the chat once this starts so I know that you guys can hear it and my audio is okay. This is cranked up as far as I can go, you guys. Rubillard is sometimes very hard to hear because he's not near the microphone. And then the judge does address it later on. So you might want to have your earbuds or earphones or something on. Sometimes to hear him, he's hard to hear. The rest you can hear quite clear. Okay, so let's get going, you guys. I won't keep you waiting any longer. Let's see. Like I said, please keep the questions till the end, and I will answer that. And I will also address any super chats or stuff like that. I will put it up on screen as they come in or acknowledge them at the end because I want to rehear this myself again too. I have picked up, like I said, they are going full force. She's not waiving her right to speedy trial. So that causes a problem for the date that is set for January 2023. With them not waiving a speedy trial, they have to have her in trial within 6 months, which brings us to October. So let's listen in. I'm going to be muting myself. So please press 1 if you can hear it. Can you guys hear it okay? Okay, thank you. I'm going to mute myself now so you guys can hear it. Right there, did you guys see it? Her face looked all sunken in. So I'm just going to pause at certain points to point out a few things, but I'm basically going to let this play through, okay? Yeah, and they use toilet paper rolls to curl their hair. They wet their hair, they wrap it around toilet paper rolls, and let it dry like that. That's how they get the curls. So right here is JJ's grandparents. And you see all the other family members sitting here behind. And it's over here that I'm asking you guys to watch for, because these are the officers that were there when the bodies were discovered, as well as this big guy here. Okay?
Got some bourbon, that's even better.
Thank you. Please be seated. All right, who's covering this arraignment on behalf of the state today?
I will be, Your Honor.
All right, thank you, Ms. Blake. Mr. Archibald, you are for the defense, correct?
Yes, Your Honor.
All right, thank you, Mr. Archibald. This is the time scheduled for an arraignment. This is case CR 22-211624, State versus Lori Vallow. Mr. Archibald and Mr. Thomas represent the defendant. Mr. Archibald, how does your client prefer that I refer to her through this hearing?
Mrs. Daybell.
Very well, Mrs. Daybell is represented by John Thomas and Jim Archibald for this hearing today and have been appointed on the case. The state is represented by Lindsay Blake, and Tanya Rawlings also here for the prosecution. In this case, Mrs. Daybell, my name is Judge Boyce. I'm the district judge presiding over this case in Fremont County, and I've been assigned to preside over the case throughout its duration. In a few minutes, I will arraign you on the criminal charges that have been filed against you by the state of Idaho. Before doing that, I'll explain what will happen at this hearing and then advise you of your constitutional rights and plea options. If at any time you need to talk to your attorneys in confidence, please advise the court or them. They'll notify me and we can arrange for you to have a discussion with them off the record and in confidence if you request that. This case began with the filing of an indictment that was issued by a grand jury on May 25th, 2021. That indictment sets forth the criminal charges the state's filed against you. The indictment is not evidence, rather it lists the criminal charges that will be prosecuted by the state of Idaho. Mr. Archibald, have you received a copy of the indictment and reviewed that with your client?
Yes, Your Honor.
Very well. In a moment then, Mrs. Daybell, I'll advise you of the charges pending against you and explain the penalties associated with those charges. Mrs. Daybell, the purpose of an arraignment is to have you enter a plea to the charges contained in that information. Therefore, at the end of the arraignment, I'll ask you how you intend to plea. In that regard, you would have three options. Your first option is that you may enter a plea of not guilty. If you elect to plead not guilty, a jury trial and a pretrial conference will be scheduled in your case. Also, by pleading not guilty, you will maintain all of your constitutional rights in this case, and those rights were previously explained to you on May 26, 2021 at your initial appearance before the magistrate. I'll note that on that date, in the record of the case is a form entitled the Notification of Rights that you had signed and initialed. Do you recall receiving that form and signing it? Very well. Among those rights, and I'll go back through several of those, you do have the right to be presumed innocent in this case. The presumption of innocence is a real and important right which lies at the foundation of our criminal justice system. Therefore, unless you either plead guilty at a later date or the state proves the charges against you beyond a reasonable doubt at trial, the presumption of innocence remains in your case. You also have the right to a speedy and public trial by an impartial jury of your peers, as well as the right to see, hear, confront, and have your attorney question all witnesses who may be called to testify against you. During the pendency of your case and at trial, you also have the right to be represented by an attorney. As you are in custody, you have the right to communicate with your attorney at all stages of your case, and reasonable access to communication with your attorneys will be provided. At your trial, you will have the right to present evidence in your defense and the right to subpoena power of the court to compel the attendance of witnesses to testify on your behalf. Finally, if you plead not guilty, you will retain the right to remain silent and exercise the privilege against compulsory self-incrimination. This means that you cannot be required to testify against yourself. However, you may voluntarily take the witness stand if you so choose, but you cannot be compelled to do so. If you decide not to testify on your own behalf, the prosecuting attorney can make no remarks about your failure to testify and cannot imply to the jury that exercising your constitutional right to remain silent is any indication of your guilt. Your next option and second would be to stand silent and enter no plea at all. If you decide to do that, the court would enter a plea of not guilty for you, and you would continue to maintain all of the rights I just explained to you. Your third option is that you may plead guilty to any or all of the charges. However, it's important that you understand if you were to plead guilty, you would automatically waive rights, including rights under the 4th, 5th, and 6th Amendments to the Constitution, as well as similar rights contained in the Idaho Constitution. If you were to enter a guilty plea, then I would go through in more detail those rights you'd be waiving before that time. If I was advised that's how you intended to plead today. It's very important that you understand all of these rights and options that I just explained to you. And so before I go further with your arraignment, do you have any questions regarding what I've just explained for me or anything you want to ask your attorney? Very well. Mrs. Daybell, and you're brought before this court to answer for the indictment that was filed in this case, which alleges that you have committed serious crimes in that 6 felony charges have been filed in the grand jury's indictment. Before I allow you to respond by entering a plea to the charges in the indictment, I'll ask you a few questions. First of all, did you have any questions about your right and plea options in this case? All right, and have you seen a copy of that indictment and had it provided to you? And have you had enough time to review that indictment with your attorneys? Very well. At this time, I will review the charges contained in the indictment and the possible penalties for those charges. The indictment charges under count 1, the charge of conspiracy to commit first-degree murder and grand theft by deception, felony charges under Idaho Code 18-1701, 18-4003A, 18-2403-1, 18-2403-4A, and 18-2407-1B3.
Your Honor,
Yes.
we waive the reading if a summary is acceptable.
Very well. Mr. Archibald, if you read that, I'm fine with that. So that is the count contained in the charges contained in count 1, and that relates to a allegation of a conspiracy to commit murder in the first degree of Tylee Ryan and to commit grand theft by deception. I'll advise you, Mrs. Daybell, that the possible penalties associated with those charges are the conspiracy to commit first-degree murder is punishable by death or imprisonment for life. And if the death penalty is not sought, a mandatory life sentence with a minimum period of confinement being 10 years. That's the possible penalty on the conspiracy to commit first-degree murder charge. You understand that charge and the possible penalty there? Very well. The second part of that count is grand theft by deception. That's a felony that's punishable by a fine not exceeding $5,000 or by imprisonment in the state prison for not less than 1 year nor more than 14 years, and which may also contain a restitution requirement. You understand that charge of felony grand theft? All right, the next count of the indictment alleges a charge of first-degree murder, and that is in relation to Tylee Ryan. That charge of first-degree murder carries, again, the penalty of being punishable by death or imprisonment for life, and if the death penalty is not sought, a mandatory life sentence with minimum period of confinement being 10 years. You understand the charge and the possible penalties in count 2 of the indictment? Okay. Count 3 is a charge of conspiracy to commit first-degree murder and grand theft by deception. That is an allegation relating to an alleged murder in the first degree of Joshua Jackson Vallow, hereinafter referred to as JJ Vallow. Again, that conspiracy to commit first-degree murder, I've already indicated what the penalty is. It's the same as in the prior count. Do you have any questions about that charge or the possible penalty? Very well. The next part is grand theft by deception. And again, that is punishable by a fine not exceeding $5,000 and imprisonment in the state prison, not less than 1 year, no more than 14 years, and may contain a restitution requirement. Do you understand that part of count 3 as it relates to the charge of grand theft? All right, the next count relating to you in the indictment is count 4 of the indictment, which is a count of first-degree murder as it relates to JJ Vallow. Under that count, again, the charge is punishable by death or imprisonment for life, and if the death penalty is not sought, a mandatory life sentence with a minimum period of confinement being 10 years. Do you understand the charge of count 4 and the possible penalties? Very well. Count 5 then is the next count alleged in the indictment relating to you. Count 5 is conspiracy to commit first-degree murder. That is in relation to Tammy Daybell. The conspiracy to commit first-degree murder charge in that count, again, carries a penalty of it may be punishable by death or imprisonment for life. And if the death penalty is not sought, a mandatory life sentence with a minimum period of confinement of at least 10 years. Do you understand the charge contained in count 5 and the possible penalties? All right, finally, I believe the last count in the indictment filed against you is count 7. That is a count of grand theft. Grand theft is a felony in Idaho that's punishable, again, by a fine not exceeding $5,000, by imprisonment in the state prison not less than 1 year, no more than 14 years, and also may contain a restitution requirement. So do you understand the charge filed in count 7 and the possible penalties? Very well. That summarizes then the charges contained in the indictment. At this time then, I'm going to go back through the charges and ask how you plead as to each charge. Before I take that plea then, do you have any questions for the court or anything you need to discuss with your attorneys?
Your Honor, she intends to remain silent. I'll ask the court to enter and not guilty pleas for her and set the matter for trial.
Very well, Mr. Archibald, then that is her right to remain silent. The court, upon entry of that, will enter a not guilty plea as it relates to all of the counts alleged in the indictment against the defendant. That is on count 1. A not guilty plea will be entered on count 2. A not guilty plea is entered on count 3. A not guilty plea is to be entered on count 4. The not guilty plea will be entered, and on count 5 and on count 7. Having entered those not guilty pleas, then, Mr. Archibald, we'd like to discuss the setting of trial in this case. As I'm sure you're aware, there
Okay, so this is the part, you guys. I do have to stop it partway through so I don't get a strike on it. But this is the part that I want you guys to listen to, because as we know, there's already been, the judge has refused so far to sever the cases between Lori Vallow and Chad Daybell. I do believe that this will be severed for what you're about to hear coming up now regarding her speedy trial, if she's going to waive her right to a speedy trial. If she doesn't, then they have to bring her within 6 months. So pay a little bit of attention to this, because this is going to affect the trial date that is set for January 2023. Now, whether they're going to try and move that date up to October, we know that John Pryor is already complaining about not having enough time to prepare with the trial set for January 2023. So I don't see him agreeing to move the trial date even closer. So let's see what happens here. I already know what's going to happen. I've heard this already, but this is going to cause a problem with scheduling. And she's entitled to this. As much as we don't like it, she's entitled to it. So let's continue going. Shelley says, my membership isn't recurring. I'm going to try and sort it out. Don't understand why my bank won't accept a recurring payment. Oh, that's weird. Okay, Shelley. Okay, so let's get back to this, you guys. I will mute myself again and let's listen to the end of this. There's not much left in it.
there's a companion case that is already scheduled for a trial to start on January 9th. The court's made some previous rulings that apply to this case, and we're set in that case as well, indicating that these cases would be tried in a joint trial. In order to have your client appear for that trial date, that would require her to go outside of the time frame for speedy trial. Have you discussed with your client her speedy trial rights and whether she intends to waive those to have the trial as now set, or what's your plan on the trial setting?
Yes, Your Honor, we have discussed it. She does not intend to waive her right to a speedy trial.
Okay, so you heard right there, you guys, that she is not going to waive her right to a speedy trial, which means they have to have her in trial within 6 months. That causes a problem. Like the judge had just mentioned, the trial date is already scheduled for January 9th, 2023. That is outside of the speedy trial. She did not waive her right to a speedy trial. They want it done within the 6 months, which brings us to October. So I don't know what is going to happen in that. I'm assuming there's going to be some more hearings in the Chad Daybell matter where there's going to be a motion to sever. Also, we're going to be watching over the next little while, you guys, because there's going to be more hearings on this, because I do believe that they are going to be asking for the death penalty in this case also. Right now, she's just being arraigned on the charges. Once they have had a chance to go over everything, I generally say within the next week or two, we are going to hear the prosecution come back and say that they are seeking the death penalty. If they don't within the next couple of weeks, they may not be seeking the death penalty in Lori's case, which also would make some more problems for the trials being joined, because one's going to be a death penalty, one won't, or they're both going to be a death penalty. They're not going to budge on Chad's. Absolutely not. So I do not see them budging on that either with Lori. I do believe that they are going to go for the death penalty. That's just my opinion. We'll have to wait and see on that. But this is going to cause a major problem. And I think within the next week or so, we're going to see a motion to sever. So let's get back with this. And don't forget, tomorrow I'm going to be covering the Letitia Stout case. That starts at 4:30 p.m. Eastern. Okay, so let's get back to this.
All right, I'll note that the defendant's in custody. There is a statutory requirement under Idaho Code 193501 subsection 1, which does require that the matter be set for trial within 6 months if speedy trial is not waived. That would give a deadline of approximately October 19th for the trial to commence in this case. Counsel, with that in mind, and a prior trial setting already slated in the companion case for January, I'm going to consult with counsel and discuss the setting of a trial in this case, making sure we can all confirm with our calendars when that can take place. I'll ask the state at this time, Ms. Blake, there's been a request in the other companion case for a trial of a duration of 10 weeks. And if this matters to go forward with both defendants now, is the 10-week trial setting that has previously been scheduled sufficient time to have the case tried?
Yes, Your Honor. The state would be asking for 10 weeks.
Okay. Mr. Archibald, having consulted with your client and reviewed the evidence, I think at this point, at least to some extent, as I'd note the case has been stayed, but you've been appointed for some time, do you believe that that 10-week trial setting is a sufficient amount of time?
Yes, Your Honor.
All right. All right, well, with that in mind then, counsel, I'm going to review calendaring and we'll get a trial set within the speedy timeframe limits if your client's not going to waive that right. So we'll look at a setting that would likely occur in mid-October for trial in this case. Does the state have anything they want to add or be heard on in terms of the trial setting, Ms. Blake?
Your Honor, I think with the request to have the trial held within 180 days, it sounds like this court is going to look at the court's calendar. I think the state's thought process would be we'll look at our calendar as well. Right now, there is a court order indicating these matters will be tried together, and there had been a severance motion which was denied in the companion case at this point. But we will look at the state's calendar and request the opportunity to provide briefing to the court if the court would allow that with regard to whether or not a separate trial should be set.
Okay, we will take that under advisement. It's a decision that obviously needs to be set quickly, the trial setting with a limited time frame for us to make these arrangements for trial. And so I will contact counsel about calendaring, which we can do off the record, and confirm dates for the commencement of a trial. The presumption being at this time that it would be a single trial together with both this case and the companion case of State versus Chad Daybell, case CR 22-21-16-23, to be tried together. But if the state believes that's not the case based on the previous rulings, I'll consider that. However, we'll set out a scheduling order, and I'll advise counsel that we'll need to have these dates sorted out by the end of this week, because I'd like to get the matter on the calendar so that we can start making arrangements for trial.
And Your Honor, if I may just clarify, it is the state's belief that they are to be tried together. I think when I was referring to the briefing, it was if we were going to, for any reason, set a separate trial date sooner than that January date, then we just request an opportunity to brief that issue. But it is the state's belief these are one matter for trial, just to clarify that.
Okay, understood. And also, given the nature of that proceedings here, I think we have to have Mr. Pryor's input as well, as potentially this will affect his currently scheduled case for trial. So that will, I believe, conclude what we need to cover today on the hearing for the arraignment. And I'll get together with counsel to determine trial dates, and then we'll get a scheduling order out once that's been confirmed. Mr. Archibald, is there anything else we need to bring up for the defense today?
No, thank you.
All right, Ms. Blake, anything further for the state?
Your Honor, I think the only other thing the state had to mention today was the state has filed a motion for a joint status conference in the two case numbers. It sounds like we may be having one anyway when we're talking about setting trial dates. So there may be no need to address that. We were just going to request a date be set on that matter since counsel was here.
Okay, I'll reach out to counsel and see if we can cover those issues you wanted to cover in a status conference when we do our scheduling. And with that in mind, then, that will conclude the hearing today. I appreciate the everyone's complying with the court's order as it relates to maintaining demeanor in the courtroom this afternoon, and we'll be in recess.
All rise.
Okay, so there you go, you guys. That's what we've got so far with Lori. So I do believe that this is going to cause an issue. I do not think that John Pryor is going to be very happy about the trial date possibly being moved up. Well, we know the court has to try Lori by October. They only have 6 months because she did not waive her right to a speedy trial. So they cannot force her to have her trial any later than October, starting in October, which is cutting it close. Even if they do sever these cases, they're saying 10 weeks. So that's 2.5 months. If they start mid-October, that's going to bring them almost right up to the date of the beginning of the next trial. The prosecutors are the same in both cases. So if Lori's happens to run later than the allotted time, there's going to be a problem. So I do feel that they are going to try and get it maybe in September. That's just my opinion, to give them that little bit of cushion in case the trial runs longer than the 10 weeks. If it's set like the end of October, you've got November, December, and then half of January. That's not going to work. So, and even on the other side, if it's set for the very beginning of October, you've got all of October, November, and part of December, you're taking a chance that it could run into the next trial date start for Chad would be January 9th. What if something comes up and they do need an extra couple of weeks? You don't want to put yourself in that position, whether you're the prosecutor or the defense. The defense really, in this instant, wouldn't really be bothered unless they have another trial that they're scheduled to do in another case. But it doesn't look like John Archibald or John Thomas are willing to budge on that, and they look determined, ready to go, and they want to go forward. So yes, John Pryor is going to blow a gasket. So we're going to be having upcoming hearings, and I believe the one that's going to be the most important is the motion to sever. I do believe that it's going to be John Pryor that's going to bring that back now, because now he has good reason to ask for that, which leads us to another problem. Lori wants to be tried in Ada County, the same as where Chad is being tried, which means the budget that they've set for one trial is now going to be doubled if it's held in Ada County, which means it's going to be well over $1 million in expenses for Fremont County to cover 2 trials, 2 juries. I think it was like an ungodly amount, like a couple of $100,000 just to house them, the juries. So this is going to be double expense, which is going to maybe give some leeway to the prosecution to have the trials held in Fremont, but the jury selected in Ada County, and just sequester them in Fremont County. But then you're running into another problem with your jury. The prosecution doesn't want to piss off this jury, because by selecting the jury in Ada County and bringing them and sequestering them in Fremont County, you're basically incarcerating them to be a juror, because they're not allowed to leave. They're not allowed to associate with people. They're not allowed to, they can talk with their family and that, but they're not allowed to discuss the case or anything like that. So they'd be basically in jail, which is not fair to the juries, to the jurors. So this is now a nightmare, and this is a tactic used by Lori's defense team. And whether we like it or not, they made the right call. And I'm going to say that the same as the Morphew case. I'm pissed, but it was the right call. So it's a no-win situation for Fremont County. The clerk has made it very clear, being around the $500,000 mark for one trial, if they have to double that, and they're saying that that's going to hurt their budget, they don't have that kind of money, set aside for stuff like this. Something's going to suffer, whether it's policing or court security or something is going to suffer that is just as important as a trial. So it's like you're in a catch-22. What do you do? What do you do at this point? It's going to be some pretty tough calls that are going to have to be made here, especially if they get a sever. And I believe they're going to, because John Pryor already has a trial date and he's not happy that it's as soon as it already is. He wanted more time. He wanted October of 2023. But now the trial date set for January 9th, 2023. He is not going to agree to have that pushed back to October or September of 2022. He's not going to agree to this at all. And it would leave it open for, opens it up to a lot of problems, especially appeals from the defense side. The judge did refuse Rosie, but that was before it was entered into court that she was brought back to competency. He said he's going to deny it because right now the trials could still be together. Also, at that point, the judge didn't know that Lori was going to not waive her right to a speedy trial. And I think we all assumed that her defense team would want that extra time to prepare. But no, they want to go ahead, and they want to go ahead within the 6 months. They are not waiving their right to a speedy trial. And that's her right. Right? So as much as we don't like it, it's the law. So we got to pick our battles type thing. You know what I mean? Death penalty cases, yes, there's always appeals. But if you can get your case thrown out on a technicality, then you can't give them any ammunition. Okay? The prosecution doesn't want to give any more ammunition than what they have to. And some of that is even conceding to certain things and maybe not fighting for certain things that they are entitled to, so they don't give the defense the opportunity for appeal. Hi, Missy. Thank you for being here. And Kat and Rosie. Thank you, all my mods. I love you guys. So, I mean, there's a lot at stake here. And like I said, there's going to be some hard decisions that have to be made. Now, I do have the links for Chad's hearing yesterday. I went over it a bit with you. Basically, it was a lot of fighting over the cost of having the trial fully in Ada County. Hello, Joy. Hello, everybody coming in. I'm sorry if I've missed you coming in. There was a lot of fighting over that, and there was some other things at the end. So if you do want to watch those, they're very lengthy. They're like an hour or two each one, and there's 3 segments. So I will put the links to those in the description of this video if you want to go over there and watch all of Chad's hearing yesterday, but it is very lengthy. And like I said, a lot of it was this fighting over the cost of transporting witnesses and the defendants and court personnel and the lawyers and this and that, everything to Ada. to appease not having to transfer a jury. And the cost of doing it in Ada County was up over the $500,000 mark, whereas just picking the jury and housing the jury under sequester in Fremont was around the $300,000 mark. So a savings of over $200,000. So you got to take that into perspective, you guys. If this is severed, double that now. So instead of, if the judge does agree to transport the jury and sequester them in Fremont, it's going to be for 2 trials, and if it's severed, and it'll be $600,000. If it's held in Ada County, 2 trials are going to be over $1 million. And that's just the basics. That's regular paid hours to court personnel and clerks and everything else and officers and this and that. But it also puts that Fremont County at a disadvantage because they're not going to have the personnel to handle issues that happen in their own county. And it's going to cut into funding for other services that Fremont County relies on. So I don't know, you guys. I'm very conflicted. I don't think it's fair to jail, and I say jail because sequestering the jury for 10 weeks is like putting them in jail for 10 weeks. I don't think that's fair to any jury member. But then again, you got to look at the other side where everybody, including family that want to be present for this trial, it's 750 miles round trip from Fremont County to Ada County. So the expense of even family being able to sit in where they are, that's their right to be able to sit in on these trials in the deaths of their loved ones. Are they going to travel 750 miles a day round trip? Or are they going to incur expenses to stay in Ada County Monday to Friday for this trial? Is that fair to the family? They're victims too. Is it fair to the witnesses to keep them away from their family? Whereas in Fremont County, they can see their family every day. They go to court every day. They come home. They kick their feet up. They make their dinner. They sleep in their own beds. Is it fair? And what Archibald had argued, and what is going to argue, because what John Pryor, from what I've seen has already argued, and you can go and watch that. Like I said, I will put those links in the description of this video once it's on YouTube, uploaded to YouTube. So please give me about 10-15 minutes to do that once the live ends. John Pryor has already made that exact point. He says, nothing else matters except for a fair trial for my client. He is entitled to a fair trial. What is fair for him? So he wants the judge to disregard what is fair and what's not fair to jury, what is fair and not fair to Fremont County Treasury, what is not fair to the witnesses and family members. He doesn't want the judge to consider that. He only wants the judge to consider what is fair to his client. The witnesses are, their lodging and meals is covered by the county. But if you are going as a spectator, i.e. family member or a close friend, you're not covered. And the family, especially the family, has a right to be there. Are they going to be required to go either daily, 700 and some odd miles round trip for their rights, or out of their pocket? The prosecution is not going to pay for their lodging for family and friends. So I mean, it's the judge is in a very bad predicament. Take care, Missy. Love you, girl. So, oh, you're welcome, Shelly. I try and that's why I ask like for questions at the end, because I try to give it to you guys in simpler terms, because a lot of people don't understand the courtroom jargon and stuff like that. A lot of you do, but there's a lot of people who don't understand, like, what's that mean? So I try very hard to go over it in terms that everybody can understand, whether you know court jargon or not. So, and I try and bring the different angles. And do I understand the defense's side? Absolutely. Your client does and is entitled to a fair trial. You got to weigh it. You got to weigh it out. Do you put Fremont County residents all at risk of not having proper policing, proper availability for court dates, etc.? Say you've got 100 people awaiting a trial, and sorry guys, you 100 have to wait because our defense, our prosecutors and our clerks are all in Ada County and cannot even look at paperwork while they're housed over there. You know what I mean? So there's a balance not only on things that are obvious, there's underlying issues that, you know, there's no more overtime for the police or fire department or whatever because their budget isn't there for it. So instead of having your firefighters being paid, you know, to stay an extra couple hours at the station, you know, they have to go home and wait for the call. There's time loss there to be able to get to the station, get their gear, and get to a fire. There's all kinds of underlying issues that you don't necessarily hear about when it comes to the county clerk and what she is responsible of, you know, doling out the money for the different services. So it's, like I said, it's putting the judge in a pickle, and he has some serious things that he's going to have to weigh upon. I think you will see a lot of that argument from the prosecution in the Chad Daybell hearing that, like I said, I will link that into this video description. There's 3 parts to it, part 1, 2, and 3. You can go over and take a look at that once I've got that up on the description once this is done. So, I mean, that's where it is, you guys. I'm waiting now. The next thing I expect to see is a conference of some kind or another motions hearing. The first one that I believe I'm going to see filed is by John Pryor for a motion to sever. And then I expect to see the prosecution filing all kinds of filings if there's a motion to sever that's granted. So that's where we're at, you guys. I don't know if you guys have any more questions that you want to ask. I will try to answer them to the best of my ability. Yes, I'm feeling all right. Allergies are in full swing, but I mean, that's normal for me. So no complaints. Yeah, it's in God's hands right now, and it's in the hands of the judge. So that's okay. Go and enjoy family first, sweet Sherry, family first. Enjoy the time with your grandkids. Okay, so with that being said, you guys, if there's no more questions from you guys, I will let you guys go, and I will get those links. Give me about 10-15 minutes. Once this live ends, I will get those links in the chat, in the description for you guys. Did the prosecution make a statement about Suzanne? Yesterday? No, they did not. I have shared that many times. I worked in the criminal justice system. I worked for a lot of different criminal lawyers. I worked for a private investigator. I did skip tracing, process serving. I did small claims. I did a lot of stuff like that in the 30 or so years that I'm now retired. So I did a lot in bail hearings, all kinds of stuff. You're very welcome. You're very welcome, you guys. Oh, thank you, Jean. You're so sweet. Thank you so much. And thank you, Shelley, for becoming a member. You're very welcome, you guys. So if there is no more questions, you guys, I will let you get back to doing what you were doing. Don't forget tomorrow. Yes and no, Shelley. I'm in Canada. These cases are all in the US. A lot of the Canadian and US laws are a lot the same, but there are some differences. So I've got to be very careful. So if I don't know, I will find out for you guys. There's no shame in learning, and I'm still learning. So even though I'm retired now, I'm still learning. Believe that. So I called it on if you guys didn't see my video from a week and a half ago, where in my title it said, is this going to be dismissed? I had a bad feeling about it. I'm just grateful that it's dismissed without prejudice, because I think if they kept going, they wouldn't have got their conviction. So with that, also watch for my live tomorrow. I'll be going live with the Letitia Stout case. I will be covering that live as it happens too. I would show you guys on here Chad Daybell's, but it's in 3 sections of about an hour and something each. And I think that it's better suited that you guys could watch that at the links I provide and give them some likes over there too, and some shout outs and thanks for them covering it. And you can watch it at your what's that? I'm going to be setting up a thumbnail for that when this live is done. I'll get that up this afternoon. So you guys, I will post it, you guys, in the community tab. So you can set your reminder right there, because I know a lot of people are having problems with the reminders. So there's a spot right on there where you can click set a reminder, or if you click on it on the thumbnail itself, it brings you up to the link on YouTube, and you can set the reminder right there. Oh, you're very welcome. That is tomorrow. So I will get that up ASAP. It is scheduled to start at 4:30 p.m. Eastern. And yes, thank you to the mods. Thank you for all you guys being here and for all your support. It's very much appreciated. Hitting the like button. It's free. Thank you for the super chats and for the memberships. Thank you so much. I appreciate everything, even the thumbs up and everything. It all counts. So thank you so much for that. So with that being said, you guys, I'll let you go. I want to go and get these links for you guys put in the description of this video, or maybe I'll put it in. I've already said description and people have left. So I will put it in the description section of this video, where you can go and watch all of Chad's hearing from yesterday. Also, keep an eye on the community tab. I will have that up for the Letitia Stout hearing tomorrow. It's a review. She should be back from her evaluation. So there's going to be a lot to see and hear there too. Okay, so until then, you guys, please take care of yourselves. Please stay safe. Love you to the moon and back. Bye-bye for now.